Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, September 20th, 2018. The time is just after 9 o'clock a.m., and we are meeting in the Hearing Board room in Diamond Bar. We have two matters on the calendar for this morning. The first one we're going to take right away this morning, which is Frontier, California, case number 6116-1 for a regular variance. And then the second one, we have given the parties until 11 o'clock this morning to attempt to come into compliance. So we will hold that hearing after this hearing, but not before 11 o'clock a.m. So who is representing Frontier, California today?
I am. My name is Patricia Chen.
Thank you, Ms. Chen. And who is representing the executive officer?
Nancy S. Feldman for the executive officer.
Good morning. Okay, so this is for the regular variance. So right now, the way we have heard this matter before as an interim variance, and that interim variance is in place through today. And let me ask, Mr. Camarena, you were not present for the interim variance hearing, were you?
I was not present. I did, however, have an opportunity to review all the documents as well as the video of the hearing, and I feel I'm prepared to participate today.
Thank you for that. Ms. Chen, Ms. Feldman, would you like to incorporate the testimony and evidence from the interim variance proceeding?
Yes, we would. Thank you.
And Ms. Feldman?
Yes, no objection to that.
Okay, so we will hereby incorporate that testimony and evidence, and I'm going to ask anybody who wishes to add additional testimony today to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Ms. Chen, your opening, please.
Good morning. My name is Patricia Chen, and I'm with PC Law Group, Counsel for Frontier Communications. We previously petitioned for an interim variance before the hearing board on August 8th. At that time, we requested a variance for two emergency generators, one at Frontier's Anza facility that's located at 3911 Contreras Road in Anza, and one at Frontier's Pinion facility at 70001 Carrizo Road in Mountain Center. Because of the rolling outages caused by Cranston Fire, both emergency generators were required to run for prolonged periods. The hearing board found good cause for the Anza facility because the emergency generator had already exceeded the 200-hour limit. But the board did not find good cause for the Pinion facility because the generator had not yet exceeded the 200-hour limit, and violation of the limit was not imminent. We reviewed the operational hours to date for the Pinion facility, and we've determined that the generator will likely comply with the 200-hour limit through the end of the year. Therefore, we are withdrawing our petition for variance for the Pinion facility. The Anza facility, however, remains in violation of the 200-hour limit, and as such, we would respectfully request a regular variance to exceed this limit through the end of the year. To establish the need for the variance, we would incorporate all prior testimony of Jorge Lopez and Masood Chowdhury, as all facts remain applicable. To bring the board up to date, Jorge will testify as to the operation of the emergency generator between the hearing on August 8th through September 13th, which is the most recent data we have for the facility. And I just wanted to check, did you all receive a copy of the latest data that we submitted to the clerk?
We just received a copy of what is Emergency Backup Generator 2018 operational hours, and it is date stamped September 19th.
Perfect.
Yes,
okay,
so
that is what we're asking.
We are up to, well, I think we're up to Exhibit 1. Thank you, Teresa. We'll mark that as Exhibit number 1.
Thank you. Okay, thank you. To recap the facts that led to the need for the interim and regular variance at the Onza facility, I'll just give you some background facts. The Cranston fire began on July 25th in the Idlewild area, and over 2 weeks it burned over 13,000 acres. Power outages occurred off and on, and each time the power went out, the emergency generators would automatically cycle on. However, due to the frequent cycling off and on, the emergency generator experienced a brownout condition, which Mr. Lopez testified to, and failed on July 30th. The facility was completely inoperable for approximately 1.5 hours overnight on July 30th. Given the critical telephone service provided by the facility, Frontier decided to use the emergency generator continuously until the rolling outages ended. Recognizing that the continuous use of the emergency generator would likely result in exceeding the permitted operating hours, Frontier applied for an emergency variance on August 1st, which was granted. By the hearing for interim variance on August 8th, Frontier had exceeded the 200-hour limit, and the board found good cause to proceed with the interim variance hearing and subsequently granted the interim variance subject to the conditions set forth in the minute order dated September 12th, 2018. These conditions included limiting the operation of the emergency generator to emergency usage, only with the exception of manufacturer recommended maintenance and testing not to exceed 1 hour during the variance period. 2, maintaining an operating log to be sent by the district on the first Tuesday of each month. 3, paying all applicable fees by September 20th, today, and notifying the clerk of the board in writing when final compliance is achieved. We request that the hearing board now grant a regular variance on the same grounds as the interim variance and extend the variance period through the end of the year. We would further request that we modify the conditions to allow for maintenance and testing not to exceed 1 hour per month. In the conditions, it just refers to through September 20th, so I just want to clarify that. One other thing we would like to request is, as you may or may not know, the Cranston fire was declared, Governor Brown declared a state of emergency as a result of the Cranston fire, and therefore we would also request a motion to waive the fees associated with the variance, if possible. And I do have a copy of the Governor Brown's executive proclamation of a state of emergency, and I can introduce that into evidence.
I think that would be wise to do. We could do that now, and then we will take up that motion separately after we deliberate and make a motion on the actual variance itself.
Sure.
And just to be clear for the record, your motion is to waive excess emission fees, not all fees, or are you moving?
According to Rule 303P, it actually says all fees. It states, all fees associated with this rule shall be waived for any petition for variance filed as a direct and proximate result of any event declared to be a state of emergency by local, state, or federal authorities.
Okay, and we will take a look at that at the appropriate time.
Sure.
Thank you. Okay, just for clarifying the motion. Is that the end of or you have more in your opening?
That's my opening, and then I would have Jorge Lopez testify.
Okay, I'm going to ask Ms. Feldman for her opening at this time, and then you may introduce Mr. Lopez.
Yes, thank you, and good morning, members of the board. Just very briefly, the district remains unopposed to the granting of a variance in this case. We do appreciate the efforts that petitioner went to determine that the Pinion location would not need a variance based on its history of usage and the remaining time of the year. So let's hope that there isn't another fire or other exigent circumstance which changes that, but if so, the emergency variance remains the appropriate route for that situation. We continue to support the variance subject to the proposed conditions. that were ultimately opposed on the interim with the slight modification of limiting the 1 hour operation of the emergency generator for maintenance as recommended by the manufacturer per month.
Thank you, Ms. Feldman. Ms. Chen, you may introduce Mr. Lopez. Yes, Senator.
On page 3, excuse me,
Of the petition?
yes, item number 6 talks about attachment A. A is in alpha. Actually, it should also be A and B, but now A has been withdrawn. B should be noted, which deals with the other engine. Attachment A deals with one engine, attachment B deals with pinion. Is that correct? That's correct.
Yes, that's correct. So yes, attachment B is no longer relevant.
Right, okay. So now just, okay, fine, very good, thank you.
Is that clear for you?
Yes.
Thank you. Okay, Ms. Chen, you may introduce Mr. Lopez.
Sure. This is George Lopez, and I'm sorry, Jorge. I keep saying George, I apologize. And what I'd like him to do is just go over Exhibit 1 with the board. So, Jorge, wait, hang on. Okay. Jorge, can you start by introducing yourself and giving us your title at Frontier Communications?
Good morning. My name is Jorge Lopez with Frontier Communications. I'm a building service technician at Frontier. I am responsible for managing the power at ANZA facility. I previously testified on August 8th, 2018 about the Cranston fire, which led to rolling outages at the ANZA facility. Due to brownout conditions and July 30th through July 31st, we were forced to use the emergency generator continuously until commercial power was restored on August 5th. In doing so, the ICE exceeded its permitted 200 operational hour limit. We requested an interim variance of 200 operational hour limit with which the board approved. Since the hearing on August 8, 2018, we had 2 power outages on August 17th and September 6th.
Can I, Jorge, on Exhibit 1, if you look at the last 2 rows, that is what he's talking about.
And I'm sorry, Mr. Lopez, can you just state for the record, I saw you take the oath, but can you please just state for the record that you did take the oath today?
Yes, I did take the oath.
Thank you. You may proceed.
The August 17th outage lasted 2 hours and 12 minutes, and the September 6th outage lasted approximately 28 minutes. Both times, the emergency generator was shut off as soon as commercial power was restored. The total run time hours for the ICE through September 13th is 255.8 hours. Since the permit limit is 200 hours for the calendar year, we continue to be in violation of the permit and will be in violation through the end of the year. Therefore, we need a regular variance to allow the ICE to operate through the end of the year. We will continue to use the ICE for the emergency use only during power outages, and we request that you allow for testing and maintenance not to exceed 1 hour per month. This consistent with the conditions you previously imposed at the August 8th hearing. We will also continue to maintain a monthly operating log and send these records to the district each month. Thank you.
Thanks, George. Jorge.
Is that complete, Mr. Lopez's testimony?
Yes, it does.
Ms. Feldman, any questions for Mr. Lopez?
Mr. Lopez, I noticed you were reading from a prepared statement, is that right?
That's correct.
Did you write that yourself, or did counsel write that for you?
That was noted.
What does that mean?
Yes, that's correct.
Well, I asked you one or the other. Did you write it, or did your counsel prepare it for you?
Counsel prepared.
Okay, and did you read and review it prior to your testimony this morning?
That's correct.
And do you agree that everything that you've just testified is true and correct?
Yes.
Okay. I don't mean to disparage the process. It's
problem.
just that you were very obviously reading from a piece of paper as opposed to extemporaneously answering a question. Given the history of this engine in past years, do you have any reasonable projection of how many hours, apart from the 1 hour per month for maintenance and testing, you may have to operate this engine prior to the end of the year?
It's possible that we may have a few hours more. It's very hard to estimate because it's at the end of the year and we're going to have rains and snow, and we may have some more outages within the next few months.
So even barring another fire, you might have an emergency that requires operation of the engine, is that correct?
That's correct.
Okay. The Cranston fire, is it fully contained and over with?
Yes.
Okay, I have no further questions.
Board members, any questions for Mr. Lopez? Nope. Thank you, Mr. Lopez. Any other witnesses, Ms. Chen?
No, not at this time, but if the board has any questions, I have Mr. Chowdhury available as well.
I think before we conclude, we move on to Ms. Fellman and we conclude the hearing. Did we receive, I would like to receive a copy of the declaration of a state of emergency by the governor.
I have it right here. Should I give it to the clerk?
Yes, and make sure that Ms. Fellman also has a copy, please. Oh, you only have one copy?
I apologize.
That's okay. We will take a break then. Yes, and Senator has a question for Mr. Lopez, but when we take a break, if we can have that copied, or Madam Clerk could tell you how to make sure that gets copied, we'll do that. Senator, you had a question?
On Exhibit 1, the first line at the very top, commencing with the 1st of January 2018, ending with February 2018, that was 27 hours. What's the explanation for that?
Yes, it's 27 hours.
What's the explanation for that? That was not the fire.
No. You have a copy of it? Yeah, we had a power outage in the area. We couldn't find out what happened there. It's just an outage from Anza Electric.
That's out of the ordinary compared to the other time periods. But you don't know what that.
No, we didn't find out until after the fact.
What fact?
Oh, after the outage, when we do our routine maintenance, we go and find out. We do the logs after we run the generator.
When did you discover that you had used it for 27 hours at that point in time?
It was on the 1st and 2nd of January, 2018.
The time accumulated was through up to the 2nd of February. Oh, first, wait a minute. End of January, you say, huh?
Yes, that's usually we're scheduled to go out there to do routine maintenance, and when we check the logs, we'll see the difference in hours, and we'll note it that day when we see it.
But you don't know why?
No, we don't know, no.
Okay, thank you.
A few questions. Can you just remind us of a few things? Is the ANSA facility a remote site?
Yes, it is.
And so it's, how often is it checked in terms of usage?
It's frequently visited once, twice a month by different personnel.
And can you remind us whether, has this generator gone over 200 hours routinely in past years?
Not that I'm aware of, no.
And are you aware, has it, to your knowledge, do you recall it ever being over the 200 hours?
Within the last 5 years, no.
Okay. And one other question for just a reminder. Can you remind us the importance of the generator in terms of during a fire, during an emergency situation, your testimony last time was that it handles emergency 911 calls, is that correct?
That's correct. It handles the whole network in the whole area, also the telephone communications for the entire area of Anza and going out of Anza.
Thank you. Ms. Berg?
I just want to also, just one thing on the record confirmed, and that is the number of hours that the generator was run during the fire was over 200 hours in and of itself. Is that correct?
No, the 200 hours is accumulation of the year, this past year, since January 1st, 2018.
Okay. Well, if I look at Exhibit 1, at the line that says 727, it says 87.7 operational hours. Is that for that period?
Yes, for that day.
Okay, and then if I look at the line that says 731 through 8/5, it says 126.4 hours. That was for that period?
That's correct. That's when we were notified and investigated that they were having rolling outages, so we decided to
Okay.
switch.
But those two added together would be more than 200 in and of itself. So the incident in and of itself would be more than 200.
And let's be clear, the incident, you mean the Cranston
The
fire?
Cranston fire.
Yes.
Okay, just wanted to put that on record. Thank you.
Any other questions? Senator?
Looks like somebody got some free electricity 1st of January, 27 hours.
I'm not sure what that comment means.
He knows.
He knows? Okay, well, for the record, do you know what that means?
No. It's just,
Can you explain why an emergency generator may or may not have operated any time during the year and how it generally works with an emergency backup generator?
generally, our generators work, they're monitoring the commercial power coming into the building. When it loses power, it senses it and then turns on the generator and switches over to the generator commercial power. When it senses commercial power is back, it will cut off, it'll switch back to the commercial power and turn off the generator.
And how many hours, to your knowledge, by permit, are you allowed to operate the generators, each of these generators in a year?
It's 20 total hours, and 12 are for routine runs, and
Did you say 20
yes.
for the year?
For the year, that's, no, it's 200 total, I'm sorry. I thought you were asking how many we usually run it.
Well, can you speak to that? How much do you usually run it in a year? Do you
Yes.
know that?
Yes, we have 12 hours of, 1 hour a month for 12 months, which is the 12 hours, and then we have 8 hours for maintenance. That's our normal.
Are you saying that over the last 5 years, which is, I believe, the time frame in which you're talking, that the Anza generator has not been used for emergency purposes?
No, it has. It's just, that's our normal routine runs and maintenance.
Okay,
And the remaining hours are for the emergency
okay.
use.
So then you wouldn't be able to testify today, over the last 5 years, what on average the generator has run overall? year.
Not at this moment.
Okay. But it has not gone over the 200 hours to your knowledge?
That's correct.
Okay. Any other questions? Okay, thank you. So, Ms. Chen, did you say you have another witness or no other witness?
No, I do not have another witness for presenting, but Mr. Chowdhury is available if anything comes up that is within his wheelhouse.
Well, let me ask board members, are there any other outstanding questions that you might have before you would be able to make the 6 findings for variance today? Because if so, we can either ask Mr. Lopez or perhaps bring on the other witness. Seeing none. Ms. Fellman, do you have any affirmative witnesses you wish to present?
No, we do have the district inspector here today. In the unlikely event you have any questions for him.
Any board member have any questions for the inspector? Seeing none, okay. What we will do at this time is we will take a 15-minute break, will probably be enough to make so let's take a break until 9:45 and we'll come back. And in that break, let's get a copy of the state of emergency declaration. We're off the record and we'll be back at 9:45. We're back on the record, and I'm just going to ask the indulgence of the parties to the case that we've been hearing, Frontier, California, for just a moment. The parties to the second case on the agenda today, AQMD versus Nite Light Signs, case number 6117-1, would like to address the board. I believe that the respondent is now in compliance and it will be withdrawn. So we'd like to have that on the record. Ms. Barrera.
Yes, the facility has come in today and they have paid with a cashier's check and the permit is ready to be issued. The district has finished their permit evaluation, so they are in compliance at this time and we do withdraw the petition.
We appreciate that, and we hope it'll move forward from here, and thank you very much for letting us know. Okay, so that, our second case, AQMD versus Nite Light Signs, case number 6117-1 is now withdrawn. Thank you very much. And we will resume with Frontier, California, and we have received, oh, Senator, did you have something you wanted to say?
Compliance. I just want to add that statement.
Because they are now in compliance.
Right.
Thank you. We have received Governor Brown declares state of emergency in Riverside and Shasta counties due to fires. And we're going to mark that as exhibit number 2. And Ms. Chen, is there any particular part of this declaration you wish to bring our attention to, or is it just the entire declaration?
It's just the entire declaration, and I apologize for the copy job because it's a little confusing, but the entire proclamation is there several times, so I apologize for that.
Okay. Okay, great. All right, so let's go ahead with your closing. Why don't we, we're going to take each of your motions separately, but in your closing, you can address both if you would like. Sorry, and I didn't call to see if any, one moment, Senator, if any member of the public wishes to be heard on this matter. Seeing none. Senator, did you have something?
Exhibit 2, 1, 2, 3, 4, 5. The fifth whereas by the governor's declaration. It said the FEMA Emergency Management Agency provided funding to mitigate the problem which existed at that time due to the fire. I'd like to know whether or not this petitioner received any funding from FEMA.
Not that I'm aware of, no.
You're not aware of it.
No, that we didn't get any funding.
If you were to have received funding, who would know?
That wouldn't be through us. That wouldn't be us. That wouldn't be Frontier Communications.
They'd be part of the mitigation overall program. Would that be, is that true, correct?
I don't think I have the appropriate personnel to answer that question here. I'm sorry. But to the best of Mr. Lopez's knowledge, he is not aware of any mitigation.
As per this whereas clause, it would suggest that they could have applied for funding. Is that correct?
I'm not sure that we can read that into this whereas clause. The plain language of the whereas clause is that the Federal Emergency Management Agency has granted a fire management assistant grant to assist with the mitigation, management, and control of the Cranston fire itself, is how I read it.
Yeah, which therefore means that they received funding and they're asking to be exempted from paying the fees.
I do not see any evidence of either an offer of assistance for emergency generators that went out as a result of, or sorry, that got run as a result of fire, or power that went out. I don't read that, and I don't believe we have any evidence. But if you read that into this, then you can raise it during deliberation.
That's what the declaration states. And that's why they included that whereas clause. The money was available if they were to have applied for it, and I'm assuming that they might have done that.
Okay, well, each board member, I think that this declaration speaks for itself, and each member of the board is free to read into it whatever the member of the board wishes to read into it. But just to reiterate, Mr. Lopez, to your best of your knowledge, was any money available, applied for, or received by Frontier California for its loss of power or running of the generator?
To the best of my knowledge, no.
Okay, I think that's all we can go on, and we'll deliberate over it. Any other questions, though? Anyone else have any questions on the declaration? Okay. Ms. Chen, your closing for both would be appreciated.
Sure. So again, this variance, our petition for variance is a result of the need of Frontier to run its emergency generator for much longer than normally anticipated as a result of the Cranston fire. The Cranston fire was declared a state of emergency and was clearly out of the control of Frontier. It did everything it could, Frontier that is, did everything they could to limit the use of the emergency generator to the absolute minimum. And the only reason it had the generator operate for a prolonged period was because of the rolling outages, which caused a brownout. And the facility was inoperable for about an hour and a half, and that because of the emergency services and communications that the facility provides, they simply could not have that happen. So they kept the generator on until the rolling outages ended on August 5th. Just the Cranston fire, as Ms. Bird pointed out, resulted in a runtime of over 200 hours, which would have been the permitted limit. And because of that, again, because of the Cranston fire, we would request that the hearing board grant a variance for the facility to continue operating through the end of the year using the generator for emergency purposes and minimal testing only. So that's the basis for the variance. As to the motion for a waiver of the permit fees, I would just, again, point to Rule 303P, which states, all fees associated with this rule shall be waived for any petition for a variance filed as a direct and proximate result of any event declared to be a state of emergency by local, state, or federal authorities. We believe we fit squarely under this waiver, and therefore we would respectfully request a waiver of all fees in this matter. Thank you.
Thank you. Ms. Feldman, any close?
Yes, thank you. Very briefly, the district does not oppose the granting of a regular variance here today, subject to the conditions that were mentioned during opening, consistent with past practice, because the fees at issue are hearing board fees and not fees that come to the district. The district takes no position on the motion made by a petitioner for a waiver of fees.
Thank you. Board members, I'd like to bifurcate our discussion, deliberation, as I indicated earlier, and I think we should first focus on the 6 findings for the variance for the ANZA facility generator. And then I'd like to take a short break after that, because I'd like to more carefully read the declaration. And then we will deliberate on, should we grant the variance, deliberate on the motion with regard to fees. Since I think it's the first one I've ever received on that issue. But I do believe, just as we found with the interim variance, that all 6 findings can be made, that they can be made at this point as well. The generator at ANZA, the ANZA facility, was at the time of the interim variance already above the 200 hours allowed in their permit and by rule and regulation of the district, and it remains as such until the end of the year. Obviously, I believe that it is due to the conditions that are beyond their reasonable control. The vast majority of the hours, in fact, over 200 hours, all by itself, occurred at the time of the Cranston fire and during the brownouts that were part of that. And so I believe it was due to conditions beyond the reasonable control. And we'll delve more into that, but clearly the fires were to such a degree that the governor had declared a state of emergency. And so just as we found it was beyond their reasonable control at the interim variance, I still find that to be the case. Requiring compliance would result in an arbitrary, unreasonable taking of property, because it would essentially mean that they would have to comply with their permit and not be able to either, one, perform any more maintenance, regular maintenance on this generator, or two, operate it in the case of another emergency. And that would be unreasonable taking a property. And just a reminder that that this particular generator, as all of them, are important in the case of an emergency like the Cranston fire, because all 911 emergency communications are among those communications that cannot be had when the power goes out without the use of the backup generator. I believe that closing or taking would be without a corresponding benefit in reducing air contaminants. We know that for each hour that the generators are operated, it is excess emissions of 2.98 pounds per hour of NOx, 0.64 pounds per hour of CO, 0.2 pounds per hour of PM, 0.24 pounds per hour of VOC, and 0.0197 pounds per hour of SO2. And given that maintenance under the conditions that are proposed, and as we're under the interim variance conditions, which are largely the same, that maintenance is limited to what is recommended by the manufacturer as making sure that those generators are ready for use. I believe I can make that finding, and any emergencies that should occur and requiring use of the generator, I do believe I could make that finding for that as well. Curtailing operations, just other than curtailing maintenance to that which is specified by the manufacturer and no more, it's not possible. So if an emergency occurs, curtailment of this generator would not be in lieu of obtaining a variance. Reducing excess emissions to the maximum extent feasible, not possible if there is an emergency use, but is accomplished by limiting maintenance to that which is required by the manufacturer. And of course, monitoring will be done as has been done under the proposed terms of the variance. Anyone else have any? Ms. Bird?
I just wanted to agree with your findings and just mention that this generator is in a remote location, so the impact may not be as great as if the emissions occurred in a community or close proximity to a community.
Thank you. Anyone else wish to make any more comments on the findings in this matter? Okay, seeing none, I will offer a motion. The matter of Frontier California, Inc., case number 6116-1, I move that we grant the requested regular variance beginning today and going through December 31st, 2018, when until it resets, the hours reset by permit and on January 1st. So through December 31st, 2018. And it will be from Rule 203B from permit condition number 4 with regard to the use of the backup generator and the hours. And it will be, which one is the ANSA? Does anyone recall which one before I have to reopen the record? Which generator number is ANSA? Let me see. Oh, I know which one. It's in the, it's G41633. Is that correct? Okay, so for that generator at, it is at 39110 Contreras Road in ANSA 91708. And I further move that we adopt the proposed conditions, which are the conditions that were in the interim variance with the exception of adding to condition number 1 on the last line, which says not to exceed 1 hour, we insert the words per month during the variance period, so that the petitioner will be allowed 1 hour per month for testing and maintenance purposes. Condition number 3 will be changed to an appropriate date, but I will say, if any, because we have not yet heard the motion on whether we will waive the fees. So if that motion passes and we waive the fees, then this particular condition will cease to have any meaning, and that's fine. And excess emissions are, as I stated before, 2.98 pounds per hour NOx, 0.64 pounds per hour CO, 0.2 pounds per hour PM, 0.24 pounds per hour VOC, and 0.0197 pounds per hour SO2 when the generator is operated. That completes my motion. Is there a second?
I'll second.
Okay, Ms. Byrd second first, so I will take that second. Is there any discussion on the motion? Senator?
Yes. I'm looking at, again, Exhibit 1. And for the 87.7 hours during the fire, been discussing, putting evidence, it was 3 days. For the 126.4 hours, based on the calendar of events, it was 5 days. Okay. The item number 1 on that, which I raised early on, is kind of suspect. 1 day, and you use 27 hours. It's already been noted in the past that the commercial power costs more than using a generator. And it's a saving to the operator if they can use the generator rather than the commercial power. So therefore, it seemed to me that somebody closed their eyes to me and allowed that encroachment to take place in under 200 hours that's allocated for this use per year. Because of the emergency and the fact that those 2 days, which generated 87.7 hours and 126.4 hours, exceeded the 200, I will vote for this. But I wanted to highlight what I already discussed earlier on, where it seems to be a problem which I thought you would be aware of, and you said you weren't. But that's okay. It still concerns me, even though you got my aye vote.
So noted. I'll just note for the record that there is no evidence that that 27 hours in January was used for any illicit purposes. 200 is allowed by permit. And I just want to point out some evidence to the contrary, which is that in the past 5 years, they have not gone over the 200 hours. And so there's no pattern to show that they would be illicitly using to save money on electricity. And I want to remind the board that this is a remote location. I don't, again, there's no evidence in my mind, but I hear your point. Anyone else have any thoughts on the motion? Okay, Senator, how do you vote?
Aye.
Dr. Lerner, how do you vote?
Aye.
Mr. Camarena, how do you vote?
Yes.
Ms. Byrd?
Yes.
I vote yes. Motion passes 5-0. Okay, we will take a few minutes. I apologize, I haven't fully read the declaration, but I think that the entire motion probably rests on the declaration. So it would be good if we reread it in its entirety and took a few minutes to do that. So we'll go off the record just until board members have an opportunity to do that. We're off the record. Yes, we're ready. We're back on the record. Hearing board members, I open and invite discussion on this issue because this is the first time that we have, that I know of, that we've confronted this issue. Mr. Camarena, you'd like to begin?
Yes, thank you very much. The hearing board has, in fact, in the past, prior to your coming on the board, Ms. Prusak, granted waiver of the fees when the governor, and the last time it was the governor, had declared a state of emergency. I would point out that Rule 303P places no condition on the waiver. It says that the fees associated with this rule, Rule 303 on fees, shall be waived for any petition for a variance filed as a direct and proximate result of any event declared to be a state of emergency by local, state, or federal authorities. Places no condition. When the governing board adopted this provision, they were concerned about two things. Number one, for some entities, it takes quite a while to, maybe hours or perhaps even days, to cut a check in order to pay the filing fee on a petition for a variance. The clerk of the board does not accept a petition for a variance without the filing fee. Secondly, the governing board was concerned about the effect of fires and other emergencies on communities, on businesses, and other entities, and for that reason felt that relief from the filing fee for a variance petition was appropriate. And as a result, 303P was added to the rule to require that the fee be waived. In this particular case, exhibit number 2 is, as I see it, a proclamation that a state of emergency has been ordered by the governor. So I see no reason why we should not grant the waiver.
Thank you for that history that only you can provide. We appreciate that. But I also read it the same way that you do. I read 303P as unconditional. All fees associated with this rule shall, it's a directive, be waived for any petition. And the only issue is whether that variance was filed as the direct and proximate result of the event declared to be a state of emergency. The event declared to be a state of emergency was the fires, which included the Cranston fire. And as we have now heard the testimony and we have now ruled on the testimony and granted the variance, we have determined that this variance request is a direct, let me read the language, a direct and proximate result of any event, i.e. the Cranston fire, which was declared to be a state of emergency by state authority. And so I don't think that there is any question that the motion needs to be granted in its entirety. I do note that, having read the declaration, there are specific rules on regulations that are state regulations or local regulations that have been expressly called out as being suspended. Our rules are not called out as being suspended. However, it doesn't matter regarding the clear language of Rule 303P. But does anyone else wish to? Well, no, we're having deliberation. Would you like to join in the conversation, Senator?
It's clear that that position is dictated by the governing board, which is the appointing authority. I'm surprised, however, that the city attorney's office was not aware of this policy or position. And if they were, they didn't express, had no opinion of it. I thought that it would seem to me, at least, that the attorney's office would be aware of this and so stated at the time the question was asked. And that we would concur based on the governing board.
I just, I don't mean to stop you, but I just wanted to point out, it's not a policy. It is Rule 303P. It is a rule of the district.
It's rule and policy in my, same thing.
I think that those facilities out there that must comply with our rules as opposed to our policies or the policies of the district,
They're different?
we would see a big difference.
Okay, the policy is different from the rule. The rules dictate the policy. That's what it does. You adopt the rule, then becomes the policy. Anyway, not to debate it any further, let's say it's the rule, even though it's the same thing, does require that under these circumstances, that the fee should be waived. And I would thought that we could concur in that decision based on the evidence that's been presented. For that reason, I think that I would go along with the program. I call it program, sorry about that. I go along with the request.
It's a motion by the facility, by the petitioner. And yes, just to be clear, the hearing board is subject to several rules of the district, which are adopted by the governing board. Rule 303, which dictates our fees of the hearing board, and when those fees can or cannot be waived are by regulation 303 of the district. So just to be clear. And whereas normally, because we've had many cases where there have been motions to reduce fees or to waive. That's why I asked the question of whether it was just excess emission fees, because that's my frame of reference, because we have had many of those. That is expressly stated as within our discretion. So that would be 303M, which is discretionary powers. So under that same rule, 303, the governing board has given us discretionary powers in certain situations where it's unfair or disproportionate or a hardship to waive fees. But that's different than 303P, which up until now I have not come up against, which is waiver of all fees for a state of emergency. And that is not discretionary. That's the only thing I would point out.
It's very clear to me.
I just wanted
Ms.
to
Byrd.
agree that the reading, as Mr. Camarena mentioned, as Ms. Prusak mentioned, of 303P is the same one that I find. This is the first that I have also been aware of that we have received. But it's very clear as to all fees associated with this rule shall be waived when there's a state of emergency. So I agree with that.
Any other comments on it? Then I'll make a motion. Okay. In the matter of Frontier, California, case number 6116-1, I move that we grant the motion to waive all fees in this matter pursuant to Rule 303P, waiver of fees, based on the discussion we had, based on expressly Exhibit Number 2, which is the Governor Brown declaration of a state of emergency due to the fires in Southern California, which included the Cranston fire, and our plain reading of that rule, 303P. And that completes my motion.
I'll second it.
Thank you. Seconded by Mr. Camarena. Any discussion, further discussion on that? Senator, how do you vote? Aye. Dr. Lerner, how do you vote?
Yes.
Ms. Byrd, how do you vote? And Mr. Camarena votes?
Yes.
I vote yes. Motion passes 5-0. Thank you both.
Thank you.
Both parties. Okay, so we already addressed the fact that this is the last hearing of today. Is there any other business, board members? Seeing none, we are adjourned for the day. Thank you all.